Good morning, everyone. Thank you for joining us for today's webinar. We are recording this session and we'll send out a link to all members in the coming days. Today we're talking about the critical topic of Queensland's new positive duty to preventing sexual harassment at work. And we're going to be, we've got some practical strategies to translate the legal obligations into meaningful action. We are joined by Clinton. He's a senior workplace relations consultant, and he's going to help us navigate this evolving legislation. Clinton, thank you for joining us.
Thanks, Summer.
If you do have any questions throughout the session, feel free to use the raise your hand or pop them in the chat, and we will make sure to come to those throughout. If you're joining us on the recording, make sure to add any questions in the comments and we'll get Clinton to answer those afterwards. But I'm going to hand over to you now, Clinton. Go ahead.
Thanks for that, Summer. Good morning, everyone. So what we'll go through today, which is a bit lengthy, but we'll go through it and we'll take a bit of our time. But yes, as Summer said, I'm one of the workplace relations consultants here at MPAQ, and what we're going to do is to go through federal legislation as well as state legislation and some practical cases that have happened as of late, as well as cases that have happened not too long ago that are quite relevant to sexual harassment. So that is the agenda. So the legislative landscape, some serious cases, and we'll go through some practical steps. So why is sexual harassment so important? And that's a question that usually I get sometimes. Well, it all essentially stems from the Me Too movement. So long gone are the days where sexual harassment complaints can be swept under the proverbial rug. So the Me Too movement was a positive and very public response to the very public outing of the Weinstein sexual harassment allegations. And the movement itself demonstrated a very real shift in public sentiment, acknowledgement that this type of conduct is not acceptable, and it has given victims a voice. And we've seen and will continue to see this societal movement affect our workplaces in a big way. So the Me Too movement founded a big shift in a lot of countries, including Australia's emphasis on sexual harassment, and has since brought about new targets and legislation in relation to sexual harassment and the threshold in which companies must investigate, train, and understand harassment. So the first topic of the agenda, well, what about the legislation? So what exactly is in the legislation with regards to sexual harassment? So we'll go through federal legislation regarding that. So the Respect at Work Amendment Act was aimed to make sure more workers are protected and empowered to address unlawful sexual harassment in the workplace. So the Respect at Work Amendment Act changed the Fair Work Act in the following ways. So it introduced definitions of sexually harass and sexually harassed at work. It expanded the anti-bullying jurisdiction of the Fair Work Commission to allow it to make orders to stop sexual harassment at work. And it clarified that sexual harassment in connection with an employee's employment can be a valid reason for dismissal. So what is the definition of sexual harassment? So what I've done here is I've just placed the definition in the federal legislation. So sexual harassment means where well, let me start from the top. So a person sexually harasses another person, the person harassed, if the person makes an unwelcome sexual advance or an unwelcome request for sexual favors to the person harassed, or engages in other unwelcome conduct of a sexual nature in relation to the person harassed, in circumstances in which a reasonable person, having regard to all the circumstances, would have anticipated the possibility that the person harassed would be offended, humiliated, or intimidated. So conduct of a sexual nature includes making a statement of a sexual nature to a person or in the presence of a person, whether that statement is made orally or in writing. So it's a very, just from reading that, it's very broad, but we'll go through a few examples of what that exactly means. So that's the federal legislation. With regards to Queensland, because states also have anti-discrimination and sexual harassment legislation of its own, the relevant anti-discrimination and sexual harassment legislation in Queensland would be the Anti-Discrimination Act of 1991. There are slight differences between the federal and state legislation, which we'll go through today. So examples of sexual harassment, because as you can see from the definition under the federal legislation, it doesn't really give those specific examples, but these are some examples that have been generally accepted or been observed in certain matters. So intrusive questions or comments about an individual's personal life, unwelcome comments about a person's sex life or physical appearance, making orally or in writing any remark or statement with sexual connotations, physical contact, of course, or sexually offensive comments, anecdotes, or jokes. So that's a very broad examples of what can be accepted or considered sexual harassment. So now, just regarding the respect at work changes, federally, so the changes represent a significant shift away from a reactive complaint-based system to one where an organization must proactively prevent its employees, workers, or agents, and the organization itself from engaging in discriminatory or harassing conduct. So an organization is also responsible for protecting its employees and workers from being subject to discriminatory or harassing conduct by third parties, such as customers and clients. So positive duty, which is a term that you can see on the screen, it's not actually defined, but what is reasonable and proportionate to one business compared to another will depend on a number of circumstances, such as the size of the business, the duty holder's resources, the practicability and costs to eliminate conduct, as well as other relevant matters. So the expectations for a smaller business might be to ensure the policies are updated and they do some basic training, but for a larger business, the expectations are likely to be much bigger. So the positive duty is similar to the duty for persons conducting businesses or undertakings under work health and safety legislation to eliminate or reduce risks to the health and safety so far as is reasonably practicable. So what I've just put on the screen are like, it's essentially like a diagram to give you a bit of a practical kind of understanding, as well as something to see in terms of what we would consider or determine to eliminate sex discrimination and sexual harassment. So duties will extend to conduct by third parties, such as customers or clients, like I said before. And what we normally would start with is identifying those risks. So what can happen? What are things that may occur in the workplace that we should be mindful of or consider some measures or preventative measures? So that would essentially be step one. Step two would be assess what reasonable and proportionate steps can be taken. As I said earlier, not every business is the same. Some businesses are small businesses, which are like 14 or less full-time, part-time, and regular and systematic casuals in total, whilst large businesses, which are 15 or more employees, have a bit more of a, I guess, bigger responsibility or bigger understanding of what they need to actually do in terms of what's reasonable and proportionate. Reporting culture, so what are your mechanisms in place if in the event something was to happen, or if there was an incident, how is the business going to address that? Clear policies and training on positive duty. So what is the actual written framework that businesses actually implement, that employees as well as the business can refer to if in the event that there is an incident that needs to be investigated? And training. So training is actually pretty key because a lot of people or businesses tend to think that if I implement this policy, I'm okay. That's usually not the only thing that we have to do. Well, what we should also be mindful of is putting it into practice. So have we actually walk through or talk through the policy with our staff? Like, have we given them education regarding what sexual harassment means? Have we told them in a meeting that if in the event that this was to happen, this is who you report to? So this is essentially like a practical or visual guide to think about when it comes to positive duty, but we'll talk more about that as we progress. So in regards to the respected work, so as I was saying before, the Fair Work legislation amendment in 2022, it essentially amended the Fair Work Act to prohibit or ban sexual harassment in connection with work, including in the workplace. So these changes applied from the 6th of March 2023 and expanded the previous protections around sexual harassment in the workplace. So the protection applies to workers, including employees, contractors, work experience students and volunteers, future workers, and people conducting a business or undertaking. The protection won't apply to sexual harassment that starts before the 6th of March 2023. But essentially, why is this important? Well, a person or company can be liable for sexual harassment conducted by an employee or agent in connection with work, including if they were involved in the employer's contravention. So this applies unless the person or company can prove that they took all reasonable steps to prevent the sexual harassment. So that's pretty key, because what that emphasizes is just the liability that attaches to employers if in the event sexual harassment occurs. So in order for a business to be able to demonstrate that they've taken appropriate steps or they've addressed it appropriately, they need to be able to show that, well, these are the mechanisms that we have in place to deal with sexual harassment, and these are the steps that we had taken to record it, investigate it, and deal with the appropriate actions towards that person. So in addition to those changes in 2022, the Commission now has greater powers to deal with workplace sexual harassment. So in addition to its existing Stop Sexual Harassment Order powers, the Fair Work Commission can deal with disputes about sexual harassment by conciliation, mediation, or making a recommendation or expressing an opinion. Where a dispute can't be resolved these ways, then the Fair Work Commission may also be able to deal with the dispute by arbitration if the parties agree. If this happens, the Fair Work Commission can make an order for compensation or lost wages, or require a person to do something that's reasonable to remedy any loss or damage suffered. So applications to the Fair Work Commission can be made by a person or group of people alleging sexual harassment, such as a worker or a group of workers, or an industrial association, such as a union, on behalf of their member or members. What I've actually just wanted to talk through is a practical case that's recently happened. So the Fair Work Commission has actually warned workers there are now higher standards for physical interactions in the workplace after it threw out a veteran employee's claim that he was unfairly sacked for touching a female coworker inappropriately as he squeezed past her. So the case that I've just put on the screen is John Tamilayunis, I apologize if I butchered that, against Alcoa of Australia Limited. So this occurred in 2024. The background is there, as you can have a read of it on the screen. So essentially, the applicant claimed his summary dismissal from the company's refinery in Western Australia for touching a colleague on the bottom was unfair, as any contact was unintentional, and he had apologized soon after. So the female colleague alleged that while she was talking with other employees in a small office at the refinery, the applicant forced his way through a narrow gap between her and a desk that meant he had to physically touch her. So the Fair Work Commission's reasoning, because they dismissed his application, was that the recent amendments to the Fair Work Act, which specifically identified sexual harassment as a valid reason for dismissal, reflects a societal recognition that sexual harassment has no place in the workplace in the same way as violence or theft don't. So these are types of conduct for which the provision of and service of a notice period is not appropriate, because the conduct goes to the heart of trust and confidence that the employer has in the employee, and because of the risk posed to others in the workplace. So what does that mean? So essentially what that means is sexual harassment is very much equivalent to serious misconduct. So serious misconduct is actually defined in the Fair Work Regulations of 2009. And prior to these changes regarding sexual harassment, they would stipulate examples of what would be considered sexual harassment, such as theft or assault. So what has happened now is that these amendments have also expressly indicated that sexual harassment can be considered serious misconduct. So it solidifies that sexual harassment is of a serious nature, and that if in the event it's substantiated, well, it would align with the meaning of serious misconduct, in which when we think of serious misconduct, it normally leads to an employee being summarily dismissed or being terminated without notice. So the emphasis here of sexual harassment being very serious is very much emphasized in this case. What the Fair Work Commission also outlined in its reasoning was that the media coverage and social discourse in relation to these issues have been extensive, placing those in Australian workplaces on notice that their behavior will attract greater scrutiny and face higher standards than in the past, and that the bar on what constitutes consent for physical and sexual interactions has been significantly raised in the broader community and was even higher in work-related environments. So interestingly, the mining industry has a particularly, and this is what the Fair Work Commission outlined, so they refer to the mining industry having a particularly odious record of treatment of women in its workplaces. So women should be able to attend their workplaces without fear of being touched inappropriately. So the Fair Work Commission was satisfied that the applicant's conduct was sufficient to constitute serious misconduct, and therefore the decision to dismiss the applicant was not disproportionate to such conduct, albeit the adverse consequences which flow from the decision to terminate him. I'm mindful that this person was employed for 20 years, so that's a significant length of employment, and usually we would think of unfair dismissal risk, especially for someone that's been employed for that long. But as I've been saying, like when we think of sexual harassment, it's a higher bar. So if that was to be substantiated, even if an employee has been there for 20 years, the Fair Work Commission has made clear in this decision that it is of a serious nature and that the decision to terminate was proportionate to what's been substantiated. I also wanted to touch on another case. So this isn't a Fair Work Commission case. It's a actual court case. It's from 2014, but I think it's good to highlight because it gives an example of a worst case scenario for employers given the impact it's had on the person who experienced sexual harassment and the significant financial impact it imposed on the employer, who was deemed vicariously liable. So in 2014, the full federal court ordered that an employee's award of damages for unlawful sexual harassment be increased from $18,000 to $130,000. So the full federal court held that the initial award was, quote, manifestly inadequate as compensation for the damage suffered by the victim, judged by reference to prevailing community standards. So as you can see, there's a running theme here of just the terms being used. So community standards, societal changes. So it's very much influencing a lot of the decisions that are being handed down, especially with the recent changes regarding sexual harassment. So Ms. Richardson, who was the applicant or the appellant, because she had filed an appeal, she had brought a claim against her employer and a colleague alleging breach of Section 28B, subsection 2 of the Sex Discrimination Act of 1984. So that's the federal legislation. Essentially, the trial judge held that Ms. Richardson was subjected to a more or less constant barrage of sexual harassment by her colleague over a 6-month period. As a result, Ms. Richardson sustained an adjustment disorder, which continued for up to 2 years, causing her to change jobs and adversely affected her personal life, such as her sex life. And the trial judge awarded her $18,000 based on his findings. However, the full court, because she had appealed that decision, went on to say that the existing range of awards relied on by the trial judge did not accord with prevailing community standards. So Justice Kenney noted that the historically low awards for general damages in cases of sex discrimination and harassment had led academic commentators to conclude that the courts had not accorded much weight or significance to the emotional loss and turmoil occasioned by acts of unlawful discrimination and harassment. So Her Honor noted that the community's deeper appreciation of the experience of hurt and humiliation that victims of sexual harassment experience and the value of loss of enjoyment of life occasioned by mental illness or distress caused by such conduct, as evidenced by a marked increase in awards for similar injuries in other jurisdictional areas. So essentially, Justice Kenney concluded that previously accepted levels of compensation in discrimination and harassment cases, which were in the range of $12,000 to $20,000, no longer provided reasonable and just compensation. So on that basis, they allowed Ms. Richardson's appeal and increased the award of general damages from $18,000 to $100,000. Furthermore, the full court also found that there was a sufficient connection between the unlawful conduct and the employee's decision to leave her employment, and the employee was awarded a further $30,000 as compensation for her loss of income. So why is this so important? Well, the case is a reminder for employers in ensuring that they implement and maintain strategies to prevent workplace discrimination, harassment, and bullying, because the after effect, or like the adverse effects that were experienced by the employee, were quite serious in terms of what was awarded in terms of damages to the applicant. So now we'll just go to the Queensland legislation. So what I've done is I've just popped in the definition of sexual harassment under the Queensland legislation, so section 118. And we'll just move on to the next one. So section 119 also provides the meaning of sexual harassment under Queensland legislation. So when you compare the sexual harassment definition in Queensland and the Commonwealth legislation, there are slight differences, of course. The definition of sexual harassment are relatively the same, but the Commonwealth legislation defines the harasser as having made an unwelcome sexual advance, unwelcome request for sexual favors, or engaging in unwelcome conduct of the sexual nature, whilst the Queensland legislation definition is within the broader definition of the Commonwealth legislation. So very much similar by providing but they provide a more explicit definition, being an unsolicited act of physical intimacy, unsolicited demand or requests, whether directly or by implication for sexual favors, or making remarks with sexual connotations to the other person or engaging in any other unwelcome conduct of a sexual nature to the other person. So it's much more descriptive and explicit in terms of what the examples of when it comes to sexual harassment. When we think of the test for sexual harassment, when it comes to substantiating it, in the Queensland legislation, it's slightly different when compared to the Commonwealth legislation. So the Commonwealth legislation, it's whether the behavior was offensive, humiliating, or intimidating, which is an objective test. Moreover, whether a reasonable person would have anticipated that the behavior would have this effect. So it's an objective test to consider the reasonable nature, or what a reasonable person would have anticipated that behavior to be. For the Queensland legislation, it provides a subjective test as well as an objective test. So what does that mean? So when we think of a subjective test, the intention of offending or humiliating or intimidating the other person by the harasser is considered as well as an objective test. So if I apply that practically, so let's say the person says, well, yeah, I intended to sexually harass that person, or I felt like touching that person in that area. Well, subjectively, that person pretty much admits to or confirms their intention as to what they were doing. So it adds a two-pronged test in the Queensland legislation. So if we can satisfy the subjective test for that person in which we substantiate their intention, well, that can also substantiate sexual harassment. But then there's another test which we can utilize in which there's the objective test. So what does a reasonable person, what would they have anticipated by that behavior? So it gives two ways or two avenues in which sexual harassment can be substantiated in Queensland. Whilst in the Commonwealth legislation, it's just an objective test. So would a reasonable person anticipate that behavior be inappropriate? Also, the Queensland legislation provides examples of sexual harassment. So if you can remember in my previous slides, I gave a list of what examples of sexual harassment are. So in the Queensland legislation itself, it actually spells out examples of what sexual harassment could be. So it makes mention of pinching or touching, unnecessary familiarity, such as deliberately brushing against someone, sexual propositions. So it does very much go a little bit further compared to the Commonwealth legislation. Now let's talk about prevention plans. So this is pretty much what I wanted to get through today. So with respect to Queensland, under the Work Health and Safety Regulation of 2011, a person conducting a business or undertaking, such as an employer, must proactively manage the risk of sexual harassment and sex or gender-based harassment at work. So this expectation is essentially similar to what is outlined in the Commonwealth legislation. However, from the 1st of March 2025, proactively managing the risks of sexual harassment and sex or gender-based harassment at work is defined further for Queensland. So specifically, so persons conducting businesses or undertakings must prepare and implement a prevention plan to manage identified risks to the health and safety of workers or others from sexual harassment and sex or gender-based harassment at work. So the obligation to prepare a prevention plan applies where a risk of sexual harassment has been identified and control measures are needed to eliminate or minimize the risk. So what I've done is I've just captured the obligations when it comes to the prevention plan under the Work Health and Safety Regulations. So the prevention plan must focus on managing identified risks to the health and safety of workers or other persons in the workplace. So persons conducting businesses or undertakings must ensure that the plan complies with the requirements in Section 55H of the Work Health and Safety Regulations. So what I've done is what the persons need to comply with, I've just put on the screen. So the prevention plan must be in writing. They must state each identified risk, identify the control measures implemented or to be implemented to manage each identified risk, identify the matters considered in determining the control measures, describe the consultation undertaken. So what do I mean by that? Well, have you spoken with the employees to determine what those risks are, what measures can be considered, set out the procedures for dealing with reports of sexual harassment and sex or gender-based harassment at work, and set out and express in a way that is readily accessible and understandable to workers. So persons conducting businesses or undertakings, or PCBUs, must take reasonable steps to ensure workers are made aware of the prevention plan and know how to access it. And they must also consider how to communicate the prevention plan in a readily accessible and understandable way to workers, which may include considering and addressing barriers to communication and accessibility, such as language differences, because not everyone has the same level of proficiency when it comes to speaking English, literacy levels, physical accessibility, and technological proficiency. So some people may not be as technologically advanced to being able to see those prevention plans. Are there other ways to make it accessible to people, whether that's in writing or in person, like physical copies, using plain English, which can be easily translated where required and is inclusive, respectful, and culturally sensitive, and making that, like I was saying before, making the plan accessible through multiple channels. So through staff meetings, induction processes, training sessions, emails, codes of conduct, notice boards. So essentially spreading it across the business so it's very much out in the open, and employees can utilize it or see it whenever they want. So other things to be mindful of when it comes to prevention plan obligations. So clearly communicating the prevention plan to workers, it's essentially a key step in educating, building awareness, reinforcing behavioral expectations, and it supports a safe and respectful workplace culture. So PCBUs must review the prevention plan as well. So if there's a report of sexual harassment or sex or gender-based harassment at work is made, they must review that as soon as practicable after the report is made. Or if a health and safety committee for the workplace or workers' health and safety representative requests a review of the plan, then the person conducting the business or undertaking must review that as soon as practicable after the request is made. Otherwise, it needs to be reviewed every 3 years. So persons conducting businesses or undertakings may choose to utilize its own existing system. So if you already have something in place regarding sexual harassment prevention, or you have your own processes currently in place to manage the risk of sexual harassment and sex or gender-based harassment at work, which documents the identified risks and meet the requirements of a prevention plan, well, then that's good. The prevention plan must set out the procedure for dealing with the reports of sexual harassment or sex or gender-based harassment at work, including how a person may make that report, how the report will be investigated, that the person who made the report may be represented by a health and safety representative if need be, how the person who made the report and other parties will be informed of the results of the investigation, and that the person who made the report may also use the issue resolutions, procedures, and the dispute resolution process in the Work Health and Safety Act. So essentially, if in the event that there is, I guess, a difference of opinion or a disagreement with the process undertaken or the findings, well, then employees have the opportunity, or persons may have the opportunity, to raise a dispute if they disagree with the steps taken so far. So a lot of the central themes of these obligations on employers are very much focused and centralized on fairness and procedural steps. So that's a lot of what's been embedded in the prevention plan obligations. So when it comes to developing a prevention plan, so to assist members, we have developed a sexual harassment and sex and gender-based harassment prevention plan template. I believe this template should be available to all members via our website. Please correct me if I'm wrong, Emma, if that's wrong. The Queensland government have also provided various materials and information on their own government website regarding the prevention plan if members are seeking additional information in saying this. businesses may implement its own prevention plan. So if there is an intention for a business to implement its own prevention plan, then the Queensland government as well has provided guiding principles on this. And I just want to touch base on what those guiding principles are. So things to be mindful of when we think about prevention plans or implementing it, having a trauma-informed process and system. So what do I mean by that? So all interactions with individuals affected by sexual harassment or sex or gender-based harassment should prioritize safety, both physical and emotional, trust, choice, equity, and respect. So persons conducting businesses or undertakings should prioritize the person affected in decision-making, ensuring that their wishes for resolution are respected while maintaining safety for all. So it's essential to consult with the individual throughout the process and to avoid exacerbating harm. There's also an emphasis to multiple resolution options. So that should be offered, and persons conducting business undertakings should communicate regularly with those involved to ensure the process remains sensitive to the individual's needs and preferences. Persons conducting businesses or undertakings should provide access to appropriate supports and ensure that those managing incidents adopt a trauma-informed approach, prioritizing consultation and collaboration to minimize further distress. And it's recommended that a trauma-informed lens be applied when communicating and writing a prevention plan. So what do I mean by that? For example, you should avoid using terms such as complainant and complaint where possible. Instead, use terms such as person affected or affected persons and report. So it removes kind of that adversarial negative connotation that's attached, because we have to be mindful that sexual harassment has connections to trauma. So using plain or neutral language would be preferred. The other things to be mindful of is just management commitment. So leaders at all levels should aim to foster a workplace culture that is safe, respectful, and inclusive. And what do I mean by that? Well, modeling and enforcing behaviors that align with workplace policies to essentially demonstrate a commitment to safe, respectful, and inclusive behavior, addressing inappropriate behavior at an early level and in consultation with those affected by the inappropriate behavior action. So what do I mean by that? So what I mean by that is that where you notice something or things are, I guess, at a not so serious level, it's important to educate those people and make them aware of just the effects that it can have. Like sometimes jokes can be made, and sometimes that person who has received that joke may not take it so seriously. The issue with that is that if it's left unchecked, well, then it could develop into something greater, and it may lead to potential consequences to not only the employee, but the employer's own obligations. So being able to, I guess you could say, nip it in the bud sooner rather than later is always a better way. So addressing it locally is recommended. The other thing to be mindful of is recognizing that a positive workplace culture starts with leadership, but it requires all workers to engage in open dialogue and consultation to support a safe and respectful environment. So active and visible commitment from persons conducting businesses or undertakings to the prevention and management of sexual harassment and sex or gender-based harassment is critical for achieving positive changes in the workplace, ensuring the continuous management of risk. So what do I mean by that in a practical sense? So it goes to the original theme about implementing something, but not simply just implementing it and setting it and forgetting it. What's important is to make employees aware of it or persons aware of it. So if in the event that there's ever an opportunity to direct them to the relevant processes that you have or educate them of what that means, well, then it's always encouraged to do that, because when you educate them from the get-go and you make them aware of the avenues in which they can take if an incident happens, well, that's very thorough, and that just demonstrates the responsibility that the leaders of a business are undertaking. So it very much shows that you are being proactive and demonstrating your positive duty to eliminate sexual harassment. The other thing to be mindful of is understanding the risk factors. So effective education, like I was saying before, plays a critical role in eliminating sexual harassment. So building knowledge about how sexual harassment and sex or gender-based harassment can occur. So essentially what I said. So every opportunity that we can educate our staff, I think take that opportunity, so they become aware of it, and it's embedded in their line of approach whenever they work. And what are the benefits to the workplace and workers? So managing the risk of sexual harassment and sex or gender-based harassment has many benefits, of course. Those benefits include fostering workplaces free from harm, where workers feel safe and valued, improving worker well-being and morale, improving work outcomes such as job satisfaction, productivity, and reduced absenteeism. Because I don't want to say common. Let me rephrase. What can happen is where there is a sexual harassment complaint. Well, of course, when we think of people being impacted or affected by that, it leads to people explaining to their employers that they've been impacted mentally or they're unable to work. So what does that lead to? People or employees utilizing their sick leave. So that leads to absenteeism, which could lead to further or longer periods of absenteeism. So that's of course not beneficial for the business, but also it wouldn't be helpful for the employee as well, because they're losing the opportunity if in the event that they don't have personal cares leave or sick leave, well, then they're not receiving any payment. So what can that lead to? So what that can lead to potentially are employees considering the option of lodging a workers' compensation claim. So then that is an added issue that employers need to be mindful of when it comes to their own responsibilities, because sustained injury or physical or psychological injury could lead to employees making a claim, which of course that's not something that we would want, but it's inevitably, how do you say, a flow-on effect. So every time something happens, there is a flow-on effect, especially for something so serious as sexual harassment. It can lead to that absenteeism, people not being remunerated due to the sustained periods, and the potential for workers' compensation claims due to an injury in the workplace. Questions? Apologies if I was bloviating or taking my time there, but any questions from anyone?
Thanks so much, Clinton. That was really good. You explained that really, really well in an easy to follow kind of process. In terms of the sexual harassment prevention plan, yes, we will be circulating that out as a template and be able to make that available to members. I guess I just wanted to understand, what are some of the penalties regarding prevention plans if a business doesn't implement them?
Yeah, that's a good question, Emma. So currently, in the current penalty value, so if we look at the prevention plan in the legislation, where there's a failure to implement a prevention plan, it makes reference to penalty units. So the current penalty unit value in Queensland is $161.30. So that's current from the 1st of July 2024. So where an employer does not have a written plan to manage identified risks of sexual harassment or sex or gender-based harassment, it could lead to fines up to 60 penalty units. So what does that mean? So as of the current rate, as I was saying, it's $161.30. So multiply it. So $161.30 times 60 makes the total fine $9,678 if an employer fails to prepare a prevention plan. So that's not the only penalty. So the other penalty to be mindful of, well, there are two other penalties. So having a plan, but not effectively putting it into action. So that can also attract a fine. And the penalty units are 60. So if we do the math again, that's $9,678 where an employer fails to implement that prevention plan. And the other penalty is where the employer does not review the plan as required, such as after an incident or upon request by a health and safety representative, or at least every 3 years. So where they fail to do that, well, then it's 60 penalty units as well. So that's $9,678. So something to be mindful of for members is that each of these failures is considered a separate offense. So this means that multiple fines can be imposed if a business does not meet the multiple obligations. So from a non-financial penalty perspective, I think what we should be mindful of is that businesses should think of the lack of a prevention plan may lead to, like I was saying before, increase in claims for sexual harassment, workers' compensation, and potential reputational damage. So those also have associated costs. But in relation to the fines, well, it's $9,678 currently for each offense. And if you what is it called? offend for each, well, then it's going to be considered each time.
Yeah, thanks so much. That's explained it really well. And then I guess in terms of the prevention plan, the idea of it is to prevent sexual harassment, but in the event that a claim still occurs, the prevention plan would be called into action as well, I presume?
Yes, yes. So that's essentially what would be relevant in terms of demonstrating if in the event that, let's say, for example, it needs to be reviewed, or if an employee believes that appropriate steps haven't been taken, because they can dispute whether or not the business has actually done something with their complaint or the incident. So having that prevention plan is essentially the what is it called? The comprehensive kind of document to show what will be done, what has been done, and that should set the foundation to essentially rebut or argue if an employee says that a business has not actually taken steps to address sexual harassment. Yeah. Any other questions?
Sorry, just one more. In identifying risks, how does a business assess those, like what the risks are, and then implement those controls? What do they need to look out for?
Yeah, the risks would be in, I don't know if I went through this, but Section 55H, subsection 1 of the Work Health and Safety Regulations. So that's a good question, Emma. So employers are required to identify all work-related risks and other psychosocial hazards. So what do I mean by that in a practical sense? So the questions that come to mind for members are, well, the first question is, what risks are present in the workplace? So things to think about is, are there any psychosocial and or physical risks present, including the risk of sexual harassment or sex or gender-based harassment? In a more practical sense, sometimes I think about, well, what is a demographic? How many of my employees are male? How many employees of mine are female? That could assist you in forming what risks could be present. Also, something to think about is, well, where would they usually work in terms of this space? So when we think of, let's say, plumbing, they could be working in confined spaces. Is there a possibility that they may be working quite close to one another? Would there be a possibility that they may brush up against each other? These are just practical questions to think of, and not just in when it comes to plumbing, but construction sites. How open is the area or the venue? Are they also, is there a possibility that they may brush up against each other? Is it confined? So these are the types of questions to think about when it comes to risks present in the workplace. Other questions to think about is, how long and how often are workers and others exposed to risks of sexual harassment? So are workers exposed regularly, and how severe do they perceive the risk to be? How do hazards interact or combine with other risks to increase the likelihood of harm? What are the effects of exposure to these risks over time? So these questions are very broad, and one way to actually address those questions is through consultation. Hence why consultation is very important, because when you talk to your employees about this, they assist in informing you about what risks of sexual harassment they could be exposed to. So hearing what they have to say would help inform you of those preventative measures. Other questions to think about. So do workers report a psychological or an emotional response to the hazard? For example, have they said that they find it distressing or stressful or physically unsafe? Are any workers at a higher risk? So it goes back to what I was saying about demographic. Are any of them as well quite young? Are they a little bit older? And like I was saying earlier as well, have you consulted with them? So consultation is very key. The other things to think about is, well, what data can we collect to assess those risks regularly? So consultation is essentially the first step in collecting that data. Or you can actually conduct some surveys or incident reports, as well as staff turnover data. So what do I mean by staff turnover data? So some businesses implement like an exit interview, or they conduct or provide employees the opportunity to give feedback if they were to leave the business. So getting that information as well will help inform you of any preventative measures that can be used to monitor the extent and nature of any incidents such as sexual harassment in the workplace, as well as any complaints that have come through so far. So if you have experienced or had to deal with a sexual harassment complaint previously, well, that would also assist and help you be informed about the steps that you can implement in a prevention plan. So from following on from that experience, what has the business done to prevent this from happening again? Because whatever recommendations or the outcome that was taken from that incident could also assist in preparing your prevention plan moving forward. Any other questions?
Oh, good for me. Thank you, Clinton.
No worries. Well, look, thank you everyone for your time. I'm sure I'll speak to you all again as well if you call through our advice line. But yes, I hope everyone has a good morning.
Thanks, Clinton. And yeah, like we've mentioned in the email that we send out afterwards, we will have the example of risk assessment attached in that for everyone. But that's all the time we have for today. So thank you all for joining us. Thank you again to Clinton for being here today and providing this important information. If you're interested in any of our other online or in-person events we've got coming up this year or training courses, you can check out the MPAQ website to find all the details on those. But if there's anything else that you want, or if you just need to ask further questions, feel free to reach out to the MPAQ team. And I hope you all enjoy the rest of your day.